Good morning, everybody. In my previous video, the latest one, I told you how the executive in India is disregarded. And the blame squarely lies with the President of India. Let us see how the powers of the President and the governors, who are called the executive. President is an elected executive and the governors are his deputies. Governors derive their power being appointed by the elected executive, namely the president, and the constitution which empowers them to be the executive power of the state under Article 153 and powers vested in him under Article 163, 164, 166 and 167. Let us see how their powers are stripped off by the legislatures and the judiciary. For example, judiciary has struck down several presidential orders. For example, in the case of SR Bommai, presidential order under Article 356 was turned down by the Honorable Supreme Court in 1994. In SR Singh's case, the orders of the governor under Article 164 were struck down by the Supreme Court, which relates to the power of the governor to appoint ministers who are not members of any of the legislatures. Again, in Supreme Court Advocates on Record case of 1999, the Honorable Supreme Court has just bypassed Article 124 regarding appointment and management of judicial system in India. If we agree that judiciary can overlook any one article of the Constitution, it means that it can overlook the whole of the Constitution. Having taken oath to truly abide by the Constitution, do you think they are expected to ignore the constitutional articles or constitutional amendments? The Honorable Supreme Court has struck down several constitutional amendments too. Yet again, in 2018, Justice Chandrachud decriminalized IPC section 497, which related to adultery. Adultery is defined to be making sex to some other's wife without permission of the husband of that woman. Was an offense punishable with 2 years imprisonment and 2,000 rupees. One Joseph Shine has filed a case before the Honorable Supreme Court saying that I can go to my boyfriend with the permission of my husband. What is this? My husband cannot have control on my sexuality or on my body needs. Honorable Supreme Court, having agreed the contention of Joseph Shine, held that husband is not a master, wife is not a servant. So wife is not required to take permission of her husband to sleep with any other man of her choice. You please think over whether this proposition is acceptable to Muslim community. Is it acceptable to Christian community? Is it acceptable to Hindu community, Sikh community, or whatever? If it is allowed, it is a free for all. Any man can try any woman. If a poor man's wife is beautiful, or if a sick man's wife is beautiful, anybody can try her. When making sex to her is not an offense, how proposing to her will be an offense at all? It destroys the whole institution of marriage which is prevalent in India. India is the land of Pativratas. India is respected mostly for such values, social values observed by them. The funny part of this case is that the case was filed by a woman called Joseph Shine for her freedom. But ultimately, who got the freedom through the judgment? Previously, men were liable to punishment and women were treated as victims. Now, men have become free. Men are more enterprising than women in matters of sexuality, undoubtedly. This will also harm the women folk also. Now, with this fear, men may be afraid of sending their wives abroad or outside for education or for work, lest she may get attracted to any other person. Of course, that was a ground for divorce, except that men and women have no fear. Would men send their wives and daughters outside for education and employment? So this curtails the rights of women actually. Previously, with love, men used to keep properties, businesses, etc. in the names of wives. Now, does anybody do that? So this kind of judgments will harm the society, the women folk, the men, and the social structure of this country. And the judiciary is not answerable to anybody, and it is unquestionable. If a parliament enacts such kind of law, people will definitely pose questions to the legislators. They cannot move in their consciences, in fact. We have seen through 42nd Amendment, powers of the president were taken away by the legislatures. Again, through 43rd Amendment, his right to impose emergency under Article 352 was curtailed by the legislatures. The President of India is of the opinion that there is threat to Indian sovereignty by way of an external aggression or internal disturbance. He may make a declaration under Article 352. It's called emergency. Unfortunately, the Janata Coalition government, which came to power after emergency in the 1977 elections, in the guise of making reforms, in the guise of being more democratic than Indira Gandhi, introduced this 43rd Amendment, whereby the power to impose emergency of the President of India is snatched away by the Council of Ministers by holding that the President shall not make a declaration unless the Council of Ministers, comprising the Prime Minister, gives an advice in writing to do so. But unfortunately, the President of India is signing on these bills which are meant to take away his own powers. It is most unfortunate. I told you, President of India doesn't have to fear anybody. Once elected, he cannot be removed under Article 61 unless he violated the Constitution. He should freely implement the Constitution in accordance with oath of office under Article 60. Again, we see under the 52nd Amendment, which say Anti Defection Law, which is contained in 10th Schedule of the Constitution, whoever acquired the disqualifications mentioned in that bill they will be removed from the membership of the legislatures as per discretion of the Speaker of that House. In fact, it is the power of the President and the governors to decide upon the disqualification of members under Article 103 and 192, of course, with the advice of the Election Commission. That power of the President and the governors is taken away and entrusted to the Speaker. Speaker, after all, is a person elected by majority of that House. If members come into his party, he will always welcome them with a red carpet. If any member wants to go away from his party, he will not take a decision. And moreover, that Speaker himself is subject to the Disqualification Act. He is also disqualified. He is also subject to this same 10th schedule. Should such powers be taken away from the President and the governors and entrusted to a party man? So ultimately, we are running towards a political party rule. Sometimes a political party may be a caste, a family, or a person. We are going away from democracy and we are finding kings or monarchies in the form of heads of regional or small political parties. It's not good for the country. But unfortunately, under 130th Amendment, a minister is getting disqualified if he is imprisoned for more than 30 days. Since this amendment is made to Article 75 and 164, we should understand that this amendment applies only to ministers and none else. None else. All others can do crime as well. Even ministers can do. When would they get imprisoned? Police custody is not imprisonment. Judicial custody is not imprisonment. Only imprisonment after judgment is treated as being in jail or imprisonment. When does that happen? When a minister commits a crime, the magistrate has to impose punishment, and there will be first appeal to the district court, second appeal to the High Court single bench, and fourth appeal to the division bench, and then appeal to the Supreme Court. And it takes at least 15 to 20 years before a crime is crystallized and punishment is awarded. So how does it help? How does it prevent ministers from committing crimes? Other than ministers, there are several other posts, commissioners, different commissions, speakers, etc., who can also commit fraud, like whips, etc. So, would this amendment deter an ordinary citizen or an MLA or MP from committing crime? No, he is not sure of becoming a minister in future. Only very few people become ministers. Even then, the finalization of a criminal case takes about 10 to 15 to 20 years. And they will do that by there are several means and ways of delaying cases in the courts. So the power to remove a minister is at the pleasure of the President and the Governor under Article 164 and 75. Why do you entrust that power to the judiciary, which is plagued by delays and uncertainties? and that depends on the kind of advocates you employ, their experience, knowledge, etc. It is not a wise thing that Mr. Modi's government did. It's most unfortunate that the President of India will also sign this amendment, 130th amendment. In fact, it is his power to remove ministers. It is given to the judiciary and he assents to such bills. Whom to ask? Who will rule this country? There is already an outcry that the judiciary is overstepping into the domain of the legislatures and the executive. The President of India is the only elected executive in India. He should rule this country in accordance with the Constitution of India. Unfortunately, his powers are being stripped away by the legislatures and by the judiciary, and unfortunately, he is signing on such bills which is suicidal. Thank you for watching. I request you to please subscribe, share and comment on my videos. I will be glad to reply. Thank you.